We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published Cross-Examining Experts in the Behavioral Sciences. And he also published Bench Book in the Behavioral Sciences, Psychiatry, Psychology, and Social Work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what Bench Book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe that cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their crime. We also represent clients who have had their children removed by the Department of Social Services because of false allegations of abuse or neglect. Such cases are called juvenile dependency cases. These cases are conducted in special courts, closed to the public and closed to public scrutiny. Our team members have decades of experience handling these cases. There is no right to a jury trial in juvenile dependency cases. The decision in these cases is made entirely by a judge, commissioner, or referee, and they can rely upon hearsay statements of a social worker, including doctors, therapists, and others in determining if a parent abused a child. There is a general presumption in the juvenile dependency court that the parent is guilty until proven innocent. Now, you won't find that written in any book, but that's the reality of what it's like in the juvenile court. Children are routinely removed from their parents based upon reports of suspected abuse from teachers, family physicians, therapists, or vindictive spouses or relatives. Unfortunately, if a social worker merely suspects that there has been abuse or neglect, or that a child is in risk of abuse or neglect, the law allows the social worker to remove the child from the parent's home and place them in a foster home until the Department of Social Services completes its investigation or the court finds that the abuse is not true. In California, there are an average of 100,000 children in foster care each night. All too often the judge finds the allegation to be true and the children are placed in long-term foster care, while the parents are required to attend countless hours of therapy, attend special classes, and prove to the social worker and the court that they are reformed. A common and yet outrageous strategy finds the social worker advising the parent who is not suspected of abuse to obtain a restraining order against the alleged abuser, kick them out of the house, and the children will not be returned until they are removed from the house. In other words, they want the breakup of the family. We have even seen social workers demand that parents file for divorce or separation as a condition for returning the children. Meanwhile, the alleged abuser is either denied visitation or can only see the children for 1 hour or less a week, with a visiting supervisor watching every move and filing weekly reports describing the victims. If the court determines that the allegations of abuse are true, the child is declared a dependent ward of the court. Often, the accused parent will be sued by the county welfare department and assessed the maximum child support allowed by law, which will then be automatically garnished from their wages and paid directly to the county while the children are in foster care. Children are often removed from their parents' custody for up to 18 months. At the end of 18 months, parental rights can be terminated and the child adopted out to strangers. For young children, it may be only 12 months before the termination proceedings begin. Now, most attorneys are unfamiliar with the strange, bizarre juvenile dependency court system. In fact, many attorneys refuse to get involved in the juvenile court system because it is so fundamentally unfair. It is essential that parents be represented by an attorney who has experience with the juvenile court system and has the knowledge to challenge any deviation from the law that the social worker may attempt during the reunification process. Our experience informs us that the system rewards social workers who are able to terminate parental rights and adopt children out, because the counties receive federal funding when they adopt children out. The system actually requires the Social Services Department to follow a two-track process while children are in foster care. One track is designed to reunify the children with his or her parent, while the other track requires the county to make plans to adopt the child out in the event the parents have failed to complete the social worker's reunification requirements. Often, the foster family that the child is placed with has been pre-selected by the Department of Social Services as a potential adoptive home. In this way, children placed in such homes are at a substantial risk at being alienated from their parent by the foster parents, who are hoping the reunification efforts fail so that they can adopt the child themselves. If a child has been removed because of a suspicion of sexual or physical abuse, parents have an even harder time getting their children back. The mere accusation will result in parents' names being placed on a child central index, basically forever. Unless a parent can prove that the accusation was unfounded and petition the Department of Justice to remove their name from the index, something that is rarely done. There is no requirement that the agency that puts your name on the list conduct a thorough investigation. We have seen some social services departments attempt to maintain a person on the abuse index even after the allegations were dismissed by the court. When a parent's name is put on this list, they will be prevented from working in any setting where there are children present forever. They will never be allowed to volunteer as a coach, help out at school or church, or any other youth program. Simply, they are labeled a child abuser, even if there is no court finding that they are guilty. As we pointed out, the burden is on you, the parent, to prove the accusation was unfounded in order to get off the list. Now, let's take a minute to describe the juvenile court process. The process is divided into 3 phases. Phase 1 is what is called the detention phase. When a social worker receives information that a child may have been abused or neglected, or that a child is at risk for abuse or neglect, the social worker generally contacts the child or the reporting party and makes an immediate decision whether or not to remove the child from his or her parent's custody. Children who are of school age are usually interviewed by the social worker at school without any prior notification to the parents. If a social worker suspects abuse occurred, the child is taken directly from the school to an emergency shelter and then placed in a foster home as soon as one becomes available. The social worker will then call or leave a note for the parent of the child informing them that their child has been taken from them and that there will be a petition alleging abuse filed with the court within the next 2 days. In the notice, parents are instructed to appear at the court hearing where the judge reads the petition and determines if there is sufficient cause to remove the child. Having an attorney at this early stage of the proceeding can be very useful in setting the tone of the case, in making sure the court knows that there are two sides to the story. Unfortunately, most judges find that there is sufficient cause to remove the child from their parents, and the case moves into Phase 2. Phase 2 is called the jurisdictional phase. This is a phase where there is a trial to determine whether the allegation is true. Leading up to the trial, your attorney should receive and review the reports that the department will rely on in proving its case against you. Those are the hearsay documents I was talking about before. Our litigation members review these reports with our client in great detail. In cases of false allegations of abuse or neglect, attention to detail is critical because it will generally lead to an explanation of why the accusation was made and why it is false. It is also the time that we can conduct our investigation and retain our own experts to disprove the allegation. Remember, in reality in this system, parents are guilty until they are proven innocent. It doesn't say that in the law, but that's the reality. The trial is called a jurisdictional hearing. This hearing is very similar to a criminal court trial, except that there is no jury and important constitutional rules of evidence are ignored. For example, hearsay is generally acceptable by the social worker. The social worker's report can be received into evidence, and it's filled with multiple layers of hearsay from other people. Our goal is to convince the court that the accusations are false and to dismiss the petition. If the court agrees with us that the accusations are false, children can be immediately returned home. Unfortunately, when we win, our clients often make a reasonable request for an apology. Well, don't expect an apology from the social worker and don't look to sue the county. Why? The state legislature has given social workers immunity from lawsuits unless you can prove that the social worker acted maliciously and gave false statements to the court. It does occur, and our team members have been involved in some of these cases. Unfortunately, social workers can act negligently and suffer no legal repercussions. If the court finds that the allegations are true, at the conclusion of the jurisdictional hearing, we move on to Phase 3. Phase 3 is called the dispositional phase. This phase is designed to reform a parent and make it safe to return the child home. Depending upon the nature of the case, the Department of Social Services often attempts to deny parents any reunification with the child, particularly in allegations involving sexual abuse. When they are doing what the law requires, the social worker must develop a reunification plan. This plan consists of parenting classes, individual and group therapy, visits with the children, and attempts by parents to convince the social workers that they are not really the monsters that the social worker thinks that they are. The requirements can change as the case progresses, and the social worker often attempts to put on more and more hurdles in front of the parent trying to get their children back. The time and expense involved in completing This ever-evolving set of requirements can be overwhelming. Having an attorney who knows what the law requires and can keep social workers from imposing unnecessary and arbitrary requirements is critical. As parents move through the reunification process, there are review hearings at 6 months, 12 months, and 18 months, except in cases of young children where the reunification process lasts only 12 months. Each of these review hearings is critical, and that's about the best way of putting it. If the court finds a parent has failed at any of these stages, the child is at risk of being put out for adoption. Our team's goal is to make sure our clients pass each of these review hearings so that the social worker cannot adopt out their children. You're watching this video because your loved one is now caught up in this grossly unfair system. Our sympathies go out to you and to your loved one. As your attorneys, we will use our many years of experience with the system to reunify you with your children and clear your name as a suspected child abuser. I'd like to talk a little bit about the philosophy of our group. In cases such as these, the prosecution has a 98.5% win rate throughout the country. The defense wins at about 1.5%. Now, that's not our win rate. We have a 40 to 60 times higher win rate. Why is that? Well, a public defender handles 350 cases a year. Now, with 220 workdays in a year, you can imagine how much time they spend on an individual case. Now, serious felonies get less than an hour of time from the public defender because of this incredible workload. Now, for private attorneys, they typically handle 80 to 120 cases a year. Why? Because they're trying to pay for those yellow page ads. They take a lot of cases in and they plead as many of them as possible. They get a retainer and then they bargain with you and with the prosecution as quickly as possible so they can move on to their next retainer. You cannot evaluate a case until it is prepared for trial. Let me give you an example. I had a case of a grandfather who was charged with a molestation, and the prosecution thought he was guilty. Our investigator had met a Catholic priest, and he believed that the priest had information about the case, but the priest wasn't talking. Our investigator kept going back over and over and over again. On the fourth day of trial, the priest finally broke and turned over letters that had been written by our client's granddaughter. And in those letters, she said that she had sex with over 40 men in the congregation. Previously, she had been saying that she was a virgin and that the only person that she had been involved with was her grandfather. She was caught lying and making up stories. The charges were dropped on the fourth day of trial. This is the kind of tenacity we bring to continuing litigation. It is also an example of why you cannot evaluate a case until it is completely prepared, until you have all of the answers. This is the kind of tenacity that we bring to continuing litigation. We believe that the preparation must be completed before any decisions can be made about the case. We handle only 8 to 12 cases a year, and perhaps a couple of small cases that we have a special interest in. Our preparation begins on day one. We scan in all the documents, we index all the documents, we capture all audio tapes, we capture all videotapes, and they are put on our computers electronically. We prepare transcripts of all of these tapes. We prepare clips for presentation during trial and during the closing. We have a jobs list where we make a list of everything that we are going to do and the job assignments for every other member of the team that is going to work on the case. We have a chronology that we develop which we primarily get from you, and we update consistently, telling us absolutely everything that happened in chronological order. We make a witness list while we are receiving these documents so that we can contact every person that is mentioned in any report that may be of any value to us. The reason for this? You can be reading on page 65 and it mentions a janitor who is not involved in the case. And on page 650, you can read about the janitor and now he's become a key witness. How do you go back and find that address that was on page 65? You can't. So we keep track of all addresses as we see them, as we run across them, along with phone numbers and other contact information. We make an outline of every witness's testimony. We do not wait to a week before trial. We begin the very first reading of the case making these outlines. All of these documents, a jobs list, a chronology, a witness list, and outlines for witnesses are all prepared at the same time. We call it multitasking. It's extensive preparation that wins cases. Now, we can teach you everything that we're going to do on your case so that you are an equal partner in the preparation of your case. And we insist that you remain so. Remember, it's your case. Now, the prosecuting attorney will make offers whether or not you want them to. Our job is to make sure that you make an educated and informed decision on whether to accept any of these offers or whether to go to trial. Remember, there is hope. Many clients ask about coverage in their area of California. Simply put, we handle cases all over California. Our team members appear in every California county and have done so for years. We keep connected to our office electronically over the internet through PC Anywhere and other computer programs. It's easy to get around the state of California. With the use of Southwest Airlines and United Airlines, we are linked to all of California. Besides being linked to our own data files and research, our experts, our investigators, and all members of our team are also connected over the internet. This allows our team members to have instant access to all the materials that they need, no matter where they appear in the state of California. Sometimes people will say, well, gee, there's an attorney here locally who says he knows the judge, wink wink. Well, I've never seen a judge or a DA give away the case because of friendship. But what I have seen over and over again is that when we appear in the courts, we're prepared, we have our investigations done, we have our motions done, and we know what we're doing. Within the first day, the judges have gotten to like us because they recognize quality presentations, and that's what they're interested in. And that. Now that you know the politics and seriousness of the offense that you are accused of, we would like to meet with you. We will try to stop the charges from being filed, if they have not already been filed, by contacting the police and the district attorney. Maybe, if they are presented another side of the case, they won't even file. We will protect the evidence for your defense. This must be done immediately. Before you meet with us, it would be important that you prepare a chronology of events and set out everything that has happened and the time order in which it happened. Clearly mark that attorney-client privilege at the top of the document so that if it is intercepted in any way, it is protected. We also need to know about your background and any prior allegations that have been made against you. You can survive these charges. We believe that the survival is based upon preparation, preparation, preparation. Defending against allegations of this type can be costly. However, you only get one trial. You only get one chance. We cannot guarantee the outcome. Those attorneys who do that are lying to you. What we can do is make sure that everything that can be done will be done. In this way, we maximize your chances of the best outcome in your case. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published Cross-Examining Experts in the Behavioral Sciences, and he also published Bench Book in the Behavioral Sciences, Psychiatry, Psychology, and Social Work. What these two books do is train lawyers how to cross-examine experts. It also trains judges. That's what Bench Book means. In what you look for in terms of scientific reliability. We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There's a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar and closed to public scrutiny. Our team members have decades of experience handling these cases. There is no right to a jury trial in juvenile dependency cases. The decision in these cases is made entirely by a judge, commissioner, or referee, and they can rely upon hearsay statements of a social worker, including doctors, therapists, and others, in determining if a parent abused a child. There is a general presumption in the juvenile dependency court that the parent is guilty until proven innocent. Now, you won't find that written in any book, but that's the reality of what it's like in the juvenile court. Children are routinely removed from their parents based upon reports of suspected abuse from teachers, family physicians, therapists, or with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe that cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their crime. We also represent clients who have had their children removed by the Department of Social Services because of false allegations of abuse or neglect. Such cases are called juvenile dependency cases. These cases are conducted in special courts, closed to the public. Basically what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team.